Hello. I hope everyone can hear me. My name is Zach Smith, and I'm just started at Beresford booth on March 4th, and I'm here to talk a little bit today about kind of things that can happen at the early stages of a claim under a homeowner's insurance policy. Title of my little presentation is "I Thought My Insurance Covered That." Go to the next slide. In Washington, the insurance policy is considered the contract. That's how courts will construe it, and they will give it a fair, reasonable, and sensible construction. And it's from the perspective of the average person purchasing insurance, not from the perspective of the trained drafter sitting in the shoes of the insurance company. Wherein the language is straightforward and clear, that's how it'll be enforced. And when it's not straightforward and clear, it's considered ambiguous. And it's considered ambiguous if two or more reasonable interpretations are on the table. So this can often happen for commonly defined words, but that is one way that insurance companies get around the ambiguity. They define them. So even though it may have a colloquial meaning out in the world, it's defined here within the policy contract. But if they don't, if there's an undefined term, then any ambiguity gets construed in favor of the insured. Every policy, whether it's homeowner, auto, whatever, they have a section called exclusions, things that they take out of the grant of coverage. And those are treated a little bit differently. Those are strictly construed against the insurer. They must be very clear. And if you're going to enforce one or say one applies to a certain claim, then the burden is not on the insured to say why it doesn't. It's on the insurer to say why it does apply. All contractual duties that an insured can expect come from the insurance policy itself. But here in the state of Washington, there are additional duties imposed on insurers through statutory language. We've got the Washington Administrative Code, the WAC for short, and the Revised Code of Washington, RCWs. And they impose additional duties that may not be so obvious from the face of the policy contract. And they have some easy examples right there on the screen are unfair claim settlement practices, misrepresenting policy terms, if a claim has been made, or even in the making of a claim, that would be considered a pertinent communication. And then throughout the claims handling, any communications from the insured to the insurance company, those are considered pertinent communications, and a failure to respond to them could be a big problem. We've also got a piece of legislation called the Washington Insurance Fair Conduct Act. And this one in Washington makes it very prudent for insurance companies to follow the rules, because if a claimant gets done dirty or doesn't feel as though their claim was handled correctly, and they are able to prove that there was a violation of the Insurance Fair Conduct Act, then their damages can be tripled. And that is outside the policy. That is not a contractual claim, so the policy limits don't matter. That is a trebling of your damages in Washington if you can prove that they're related IFCA. Next slide. This one is a little bit of an example. So my house flooded, leaked, caught fire, and then I was told that it wasn't actually covered. So if you remember from earlier, exclusions in a policy are strictly construed. And because they're strictly construed, unless they're very, very obvious, like a real easy one is an insurance policy will not cover domestic violence. So if there's a claim made against an insured by a spouse or something, that one's pretty straightforward. That insurer is not going to have a hard time applying that exclusion, but not all of them are like that. Many of them are much murkier. And so the lower burden is just applying the same plain language of the policy, because every policy will have a handful of provisions and policy documents that make up the policy, including declarations, the definitions, various insuring agreements for different kinds of coverage, and then conditions. And often those will be what is applied to have a insurer come to a determination that something is not covered. And the way they'll do that is they'll say, well, this didn't meet the definitional requirement of an occurrence, or this doesn't meet the definition of a primary residence, or the claimant or the person who is injured is not a resident of the house or residence. And that is a lower burden than applying exclusion. That's just saying this act does not come into what is contemplated by the insurance policy. So how about a couple examples? In the first example, an insured seller is sued later by buyer because allegations that by the buyer that the seller misrepresented certain things in the seller form 17, and also for failure to disclose material information related to water problems in the home. And part of the reason she made that representation was to induce the sale. After the buyer files suit, the insured tenders lawsuit to her insurance company, who agrees that they'll defend under a reservation of rights, which means they're going to say, hey, these allegations might be covered, but we don't think when it's all said and done that they will actually be covered. So we're going to protect you from the lawsuit, but we're probably not going to pay for the judgment if one arises out of this, because we don't think that the facts are going to settle into something that's a covered loss. And still on that example. So the reason the insurance company took that position was because of the allegations that are right there in the complaint. The intentional misrepresentation, failure to disclose material acts, and it's all for stuff that was already wrong with the house. So keep that in mind. We'll go to the second example. Second example is a homeowner has two properties. She lives in one, she rents the other. She thinks that they're both insured. She thinks she's done what she needs to make sure they're covered. Her rental property sustains a fire and she makes a claim. And on the policy she has for the one that she rents, their declarations clearly say her primary address is the one she lives in, and the insured location is a different one. During the claims handling investigation, her insurer ultimately denies coverage and says basically that it was because they had no idea she was not living in the rental property and they didn't know it was a rental property. However, like I just said, the declarations indicate she lives somewhere else. And secondary residence and rental property are not defined under the policy. So what is likely to happen, or what do you think is likely to happen in each of these scenarios? Believe it or not, under example one, the insurer is probably correct. And when they look at the 8 corners comprised of the complaint and of the policy, they can look at the facts that are in there and the coverages the policy provides, and they can determine if the allegations are plausibly covered, then they need to pick up a defense. They can look outside the 8 corners, but only to find coverage. They cannot look outside the 8 corners to deny coverage. But in that situation, the stuff that was complained of likely doesn't meet definitions of occurrence or bodily injury or property damage. And many homeowner policies have real clear exclusions for claims arising out of the sale and transfer of property and for intentional acts of an insured. Turning to the second scenario, it's much less clear. Does the fact that the secondary residence was not defined under the policy or rental property was not defined, does that wind up helping the insured? Or is there more to the fact that the insured never let her insurance company know that it was a rental property. This one is going to require much more analysis and for more fact gathering before you can really figure out how we got there and whether there was some deception or whether the insurance company was just trying to avoid paying for a covered claim. Whether your situation is similar to either one, Beresford Booth is here to provide you with the analysis and guidance so you can decide how you want to proceed. If you have any of these kind of problems, give us a call. Thanks a lot. If you have any questions, please direct them my way.